Welcome to Audit the Audit, where we sort out the who, what, right, and wrong of police interactions. This episode focuses on the right to privacy, witnessing a crime, and private property, and comes to us from the BTO-SIIZ channel. Be sure to check out the description below and give them the credit they deserve and the original two-part series posted on December 31st, 2016. YouTuber and First Amendment auditor Philip Turner was filming a traffic stop just off Interstate 35 in New Braunfels, Texas, when he was approached by Deputy Cameron Shea of the Comal County Sheriff's Office.
Hey, can you go back over here for me, all right?
What's that?
Can you go stand back over where you work for me, sir?
There's something wrong with being here?
Yes, sir, there is.
What's
I
that?
don't want you to be in direct line with that vehicle. I'd like for you to go back to where you were standing. You can continue filming all you'd like, but I don't want you right here.
Am I interfering?
Well, technically, now you're starting to pose into somebody else's private property with your videoing. Yes, sir. Hey, did they give you permission to film inside their truck?
I don't need permission out in public.
In somebody's vehicle?
I don't need permission out in public.
No, not to film us, you're correct. But to film inside somebody's vehicle, that's an extension of their house, and that is a private place. So you do need somebody's permission to film inside their vehicle.
But is that a crime?
One of the deputies informs Mr. Turner that he cannot film the inside of someone else's vehicle without their permission, even if that vehicle is in a public place. However, as we've discussed many times on Audit the Audit, the First Amendment protects the right to film anyone and anything within plain view of the public eye, since individuals have no reasonable expectation of privacy in public. Although the deputy claims that a vehicle is an extension of its owner's home and therefore a private space, the diminished expectation of privacy in automobiles is well established in court decisions. In the 1976 case of South Dakota versus Opperman, the U.S. Supreme Court concluded that the expectation of privacy with respect to one's automobile is significantly less than that relating to one's home or office. The Opperman decision noted that automobiles, unlike homes, are subject to pervasive and continuous government regulation, including periodic inspections and licensing requirements. Police regularly stop and inspect vehicles for expired plates, inspection stickers, exhaust issues, excessive noise, or malfunctioning safety equipment. The court also emphasized that the expectation of privacy in automobiles is further diminished by the public nature of automobile travel. In the 1974 case of Cardwell versus Lewis, the court stated that one has a lesser expectation of privacy in a motor vehicle because its function is transportation and it seldom serves as one's residence or the repository of personal effects. It travels public thoroughfares where both its occupants and contents are in plain view. Therefore, the deputies claim that Mr. Turner cannot film inside a vehicle in a public place without the owner's permission does not align with Supreme Court precedent on this issue.
Do you have your information? Your driver's license?
What's that?
Do you have your driver's license or name, date of birth?
For what?
Because now you're a witness to this crime that we're doing.
What crime is that?
The crime that we got these people in the back of these cars for.
I don't know what crime they committed.
You don't have to know. Okay, they broke the law. They're in possession of narcotics. That's why they're in the back of our cars. So, do you have your name and date of birth?
No.
Or a driver's license?
No.
So you're going to refuse to be listed as a witness since you sat here and videotaped the entire scene?
If you need a copy of the video, I can give you a copy of the video.
Well, yeah, but we're also going to need to identify you in our report that you were here videoing, so when we come to get a copy of that video, we can get that.
All right, let me talk to your supervisor.
He said that he won't want to give us his name and date of birth until he talks to our supervisor. So.
And you're probably going to end up going to jail because right now you're witnessing a crime.
The deputies then request that Mr. Turner provide his driver's license or, alternatively, his name and date of birth. When he refuses, they inform him that he could be arrested for failing to identify himself because he was a witness to a crime. Under Section 38.02 of the Texas Penal Code, an individual can be charged with failure to identify if they intentionally provide a false or fictitious name, address, or date of birth to a peace officer who has good cause to believe that the person is a witness to a criminal offense. Therefore, Mr. Turner could not be lawfully arrested under this statute merely for refusing to provide the information altogether, only for providing false information. However, some states do criminalize a witness's refusal to provide personal information when requested by law enforcement. For example, Section 2921.29 of the Ohio Revised Code makes it a fourth-degree misdemeanor for an individual in a public place to refuse to disclose their name, address, or date of birth when requested by a law enforcement officer who reasonably suspects that the individual witnessed certain types of felonies. The Ohio statute also clarifies that nothing in this section requires a person to answer any questions beyond that person's name, address, or date of birth. Nothing in this section authorizes a law enforcement officer to arrest a person for refusing to provide any information beyond that, or for refusing to describe the offense observed. Because of the constitutional right to remain silent, individuals are generally not required to assist police officers in investigations. Witnesses cannot be compelled to answer questions unless they are lawfully subpoenaed. However, material witnesses, those who possess significant information necessary to resolve a criminal prosecution, can be arrested or detained to secure their testimony, and the 1953 case of Stein v. New York, the U.S. Supreme Court stated that interrogation of those who know something about the facts is the chief means of solving crime. The duty to disclose knowledge of crime rests upon all citizens. It is so vital that one known to be innocent may be detained, in the absence of bail, as a material witness. Many states, including Texas, allow witnesses to be arrested only if they fail to appear after receiving a subpoena to testify in a criminal case. However, under federal law, witnesses can be arrested even without violating a subpoena. Section 3144 of Title 18 of the U.S. Code states that if an affidavit shows a person's testimony is material in a criminal proceeding, and it may be impracticable to secure their presence by subpoena, a judicial officer may order the person's arrest. The statute also requires that material witnesses be given the same type of bail hearing as criminal defendants to determine whether they should be released on bail or held in custody before trial. According to the Bureau of Justice Statistics, 5,594 material witnesses were arrested in 2016, constituting about 3.7% of total federal arrests that year. While it is highly unlikely that Mr. Turner would be considered a material witness by a court, it would still be theoretically possible for the officers to arrest him in good faith, depending on the jurisdictional relationship between the local department, the state of Texas, and the federal government.
Well, I asked to talk to a supervisor. He's here, so why can't I speak with him?
Because you're refusing to give your information, you'll be going to jail for failure to identify as you're a witness to a crime.
So I need to give you my ID to speak to your supervisor? Is that what you're telling me?
No.
Okay, I need to speak to your supervisor.
Why do you need to speak to the supervisor?
Because I requested to speak to him.
What warrants that?
Because I requested to speak to him, and he's here.
Okay. So what's your point?
He's here. I need to speak with him.
You've got no part of the scene, right? But you want to speak to our supervisor.
You can speak to him.
Okay.
Yeah, but you'll be in handcuffs and it'll be at the jail. Is that what you want to do?
I need to speak to your supervisor.
Is that what you want to do?
I need to speak to your supervisor.
What aren't you understanding? You put yourself in this situation right here. You see that? You're on private property
Private
right now.
or public?
You're on private property right now.
Okay, what does that do with anything?
Do you have permission to be here?
Did the owner trespass me?
Well, this guy...
He doesn't want you here.
This guy actually did call and tell us he wanted you to leave.
The deputies informed Mr. Turner, who was standing just outside a fence surrounding the entrance to a Camping World RV sales lot, that he was filming on private property and that the owner wanted him to leave. Although the First Amendment protects the right to free speech in public places, including the right to film police interactions, it does not require private property owners to allow others to exercise those rights on their property. The First Amendment states that Congress shall make no law abridging the freedom of speech. In the 1925 case of Gitlow v. New York, the U.S. Supreme Court ruled that the First Amendment's protections also apply to state governments through the Due Process Clause of the 14th Amendment. However, courts have consistently held that private parties cannot violate the First Amendment, since it applies only to government actions. This principle, known as the state action doctrine, means that private citizens and business owners are not bound by constitutional free speech obligations. Therefore, the property owner was not required by the First Amendment to allow Mr. Turner to film on the premises. That said, Mr. Turner did not violate Texas law by filming the interaction. Under Section 30.05 of the Texas Penal Code, a person commits criminal trespass if they enter or remain on property of another without effective consent, and had noticed that entry was forbidden, or received notice to depart but failed to do so. The statute defines notice as oral or written communication by the owner or someone with authority, fencing or other enclosures designed to exclude intruders, signs indicating entry is forbidden, identifying purple paint marks on trees or posts, or the visible presence of a cultivated crop. Because Mr. Turner was standing outside the fence, and there were no signs indicating that he was not allowed to be there, he did not have notice that entry was forbidden when he began filming. Furthermore, until the deputies informed him that the property owner wanted him to leave, he had not received notice to depart. Under these circumstances, it is highly unlikely that Mr. Turner could be legally arrested for criminal trespass. After the deputies relayed the owner's request, they brought over the Camping World manager to deliver the message in person. The manager awkwardly told Mr. Turner to leave, then stepped back as Mr. Turner and the sergeant continued their discussion.
So what's up?
All right, so I can get your business card.
Yeah.
But this is what I do. I film what public officials do on public property. I'm a journalist. I gather content for stories.
That's cool.
But this officer here was telling me that I had to move back over there. I couldn't stand over there. And I was asking him why. He told me that I wasn't allowed to film inside the vehicle here. But
I mean, that's their privacy too. We got to get their consent to go in, so it makes it any different for you.
well, that's to go in.
Yeah.
But I'm not going in. I'm just observing. That's kind of like equivalent to this is his property, but I can't film it because it's on his property.
Okay.
You know,
Okay.
you see what I'm saying?
Yeah.
It doesn't make sense, and it's not against the law.
Okay.
So he needs to get educated on that because
Okay.
that's clearly not the case. Okay? Now, am I currently being detained here, or am I free to go?
You're free to go, man.
Well,
I'm here. I came all the way from Canyon Lake to
We
talk
need
to
to
you.
identify him now.
Okay.
Okay.
You need to identify me?
Yes, sir, I do.
For?
Because you're a witness to a crime and you sat here and recorded the whole crime.
I don't know what crime was committed.
I told you.
I didn't see y'all
And then
pulling
you
the
said
the car.
that you still wouldn't identify yourself until you spoke to our sergeant. Now you spoke to the sergeant, so I need to get your name and date of birth so
I can give you a
identify
copy of the vehicle. I can give you a copy of the video.
I don't need a copy of the vehicle.
I can give you a business
I need
card.
your identifying information so I can list
You
you in
just
the
need your
report
ID and
as a
info.
witness.
Yeah. You're a
I-
witness.
I
Because
don't-
right now you're failing to ID as a witness to a crime.
What crime?
Hey, what's your first name, man?
I'll give you my first name. It's Philip.
Philip.
Yes, I'll give you that.
Best case scenario, that female and that male says that we did something against the law. Eight cops against one person, right? So you know who I would want? I would want the guy who's not even involved in this to be my witness. So that's what we're trying to explain to you.
So they need me as a
Because
witness?
you're part of any type of information that anybody that comes in. We're gonna have to ID him because he's in our cameras now.
See, and I already got his business card. He already identified himself.
So he gave his name and date of birth and all that
yes,
stuff?
I've got it all right
I said
here.
I can go get a business card too. I just said that.
Well, that's fine, but here's the thing. You can't leave until we identify you.
Like I said, I already told you, I'm a journalist. I gather content
Hey,
for stories.
That's
That's
fine.
it.
Yeah, we had no problem with that, man. We just don't like the space.
And that's what I told you earlier. I didn't have a problem with your video.
Now, Sarge, am I free to go or am I being detained?
Until you give your name and info.
Initially, the sergeant attempted to justify the actions of his deputies. Mr. Turner was not given a fair opportunity to engage in conversation with the sergeant, as their discussion was repeatedly interrupted by phone calls. Between each call, the deputies continued to urge Mr. Turner to identify himself. Eventually, the sergeant ended his phone conversation long enough to speak directly with Mr. Turner.
I'm not up in your face. If I were up in your face, then you would know. You need anything from him? You good?
I'm good.
Do you want to talk to him real quick? Okay. Can you try and identify him for us?
Yeah. Let's go here. I don't like no reason to argue, man. You're not doing anything wrong, and but here's the deal. They got a point there. I mean, your worst case scenario is that your camera would be a part of evidence, but we're not going to go there because I have a camera. I have plenty of cameras going, so I don't need your camera. Now, if something were to happen to where, man, we get into a shooting or something or a fight and somebody gets hurt, then you know what? I'm taking your camera because that's so you got to be careful with that in the future. Okay, when you're doing this,
But on that one, I'll tell you, there was a shooting on 6th Street that happened not too long ago, and I helped aided them catching the shooter.
And I have no problem with that. No. But that's what's called
I
evidence.
understand.
It's not that I want your camera because I want you to stop doing this. It's just that, man, you would be surprised how many angles we need nowadays.
I understand that.
You know,